All right, good afternoon, everyone. I want to thank you for coming to our meeting. Two quick announcements before we get started. Save the dates. The annual dinner will be October 20th. You'll get more information from Mr. Lynn in the coming weeks and month, but if you want to mark your calendar, October 20th, and I think it's going to be again at the City Pier, but with an improved catering. So, for those of you who had to go out to dinner after, I know Judge Delano commented the food was inedible. Other save the date, Judge Williamson asked me to put on everybody's radar View from the Bench. So it's November 3rd in Tampa and November 4th in Miami. I think it typically starts at 9 a.m. or so, and it runs till 12:30 or 1. The Tampa one will be at Stetson University again, the campus that's downtown. I don't think, last I heard, they hadn't pinned down a location for the Miami one yet, but you'll get more information about that from the Florida Bar.
Show up early if you go to the Tampa one.
Yeah, yeah.
That's right. The seating is limited in the main, in the moot courtroom, and then what they do is they've got video presentations in some auxiliary classrooms. So yeah, show up early. All right, and then without further ado, I have the privilege of introducing our presenter today, who is one of my law partners, Michael Corso. Mike has been at Henderson Franklin 38 years. He doesn't, to me at least, look old enough to have been practicing that long. It sounds like a long time. Hopefully I won't.
Just a kid.
I won't be here 38 years from now, or 27. Mike's primary area of practice is torts and insurance defense. His specific emphasis in non-medical malpractice, including the defense of lawyers in legal malpractice and grievance claims. He's board certified by the Florida Bar in both civil trial law and business litigation. And that's impressive. But one of Mike's accolades, lesser known, that I think is most impressive is that he is literally a rocket scientist. His undergraduate degree is in aeronautical engineering, and he and Neil Armstrong are amongst the Purdue University alumni of the year in that area, aeronautical engineering. So, how many rocket scientists do you know who have shared an award with Neil Armstrong? So, I don't think Mike walked on the moon, though. All right, Mike Corso.
Thank you. Thank you very much. Thank you very much. Nice to be back. Thanks for inviting me. I think I did this gig in some form a number of years ago, and I think my cohort in crime, Tracy McKee, might have been here the last time on this. Tracy's my boss, so I do whatever she tells me to do. I've been practicing law 42 years, 38 of which was at Henderson Franklin. It's bad enough being a lawyer, but I'll tell you, it's quite a trip representing you all. So, and accountants, Mr. McHale, we do, as you know, I do some accounting work also. So, nice to be with a hopefully friendly audience. So let me start with, how many of you like lawyers? Now, come on, a couple more hands. Well, on the serious side, 3 weeks ago in a trial in Sarasota County, defending two lawyers, eminent domain lawyers, I asked that question. I had warned my clients with the jury veneer, knowing this is a jury room, that you're not going to see many hands, if any, raised. And sure enough, there were not. So, my intent with this gig is to share with you 42 years of stuff, and with some thoughts and ideas. Hopefully we keep it social and we don't have an attorney-client relationship, of which I have many in the state of Florida with lawyers and law firms. We can win these cases, and they're not easy because it's going to be something in front of a jury, and again, they're not going to raise their hands. And it takes a little bit of an effort to convince them that we're not that bad. And hopefully there's some facts in the case that support that. So give me something to work with, I guess is my other thing. And, you know, to throw into that, I've been president, managing lawyer of Henderson Franklin a number of times, which is a larger firm. And so I'm conscious of law firm type issues for those of you in a larger firm, or if you're in a managing position within your particular firm. So I'm appreciative of that. I have a bevy of law firms. I could rattle them off here. You all recognize them that call Uncle Mike fairly frequently, and they've got this issue or that issue. So it's not necessarily a claim, but there are some issues. So I kind of draw upon all of that. So, and then if I get real bored, I'll think about the rocket scientist stuff with Mr. Armstrong, the late Mr. Armstrong. Okay, can you see this okay? I know it's a little small. I don't know if this can be dimmed up here at all. At least we get done that. But I'll go through some stuff here with you, and since it's a small enough group, certainly can take questions really at any time, save some at the end, whatever. Usually when I do these gigs, it's, yeah, that's good. Thank you. That people are eating and give people indigestion, I think. So, but if I do scare you a little bit, frankly, that's a little bit of my take. I mean, my goal is to try to keep you out of this so that Mr. McHale's not suing you. Oh, sorry, Jim. Okay. Let me first start with some statistics. I am a member of the American Bar Association's this committee, Standing Committee on Lawyers' Professional Liability. I think you recognize the ABA, National Bar Association, so it incorporates, and we've got international sections now to it, so in many ways it's international, which is good because it picks up some of the European countries that have claims, and also a lot of the carriers, insurance carriers in London, Lloyd's of London, Beazley, and others, and a large base of the insurance products for lawyer malpractice insurance are in London. So there's a meeting, actually there's two every year, and there's up to 500 people at these meetings. It includes people like myself who are defense lawyers. It technically could include claimants lawyers or plaintiff lawyers. There's a lot of insurance representatives, risk managers with law firms, major law firms in the country and internationally, general counsel for those organizations. So in short, and underwriters with insurance companies. So it's frankly all the people that would know about statistics and the broad base of claims. So with that background, the ABA occasionally does surveys amongst its members, and it asks questions about what kind of claims do they have, and it goes to the insurance people, it goes to defense lawyers. I participate in it. And so I'm going to show you some statistics. Now, you see it's a 2011 study, and I think you know enough about studies. It takes them a while to do the study, it takes them a while to analyze it, and then to publish it. So this really didn't get published until late 2014 or 15. They've done one every approximately 3 to 5 years. There's one going on right now. So it may not look to you to be totally current, but it is what it is. And I think it may help you understand some things in my world. The first question is, well, how about, what about the size of a law firm? Are there any, where are the claims coming from? And by the way, if anybody wants copies of these slides, let me know and we can surely send them to you. But you will see here that here's the spread. And if you do the math real quick, or quickly, you will see that 75%, 76 I guess exactly, represent firms that are 10 attorneys or less. 3 out of 4 claims are coming from firms of that size. And then it goes down further to the other firms of other sizes. So, now what is the meaning of that? Well, I don't know that there's any meaning. I mean, we talk about, what does it all mean? And I would say that, my stats are probably pretty much in that area, although I've got a number of national and international firms that have branch offices down here that are in this category down here. But I think the general consensus of it is, as an analysis, is that to some degree, and many of you, and I know many in your practice, you're in a very specialized area, and many of you are in your own firm or a smaller firm, not all of you, but many of you. And maybe there's not 100% work in your specific area to with bankruptcy type related matters, but you're into some other things. Could be some real estate, could be some debtor creditor collection type work, and other areas. And so we often find that in the claims in this category, these persons are practicing more what we jokingly call door law. That is, whatever walks in the door. Now, I'm all for lawyers collecting a fee. Don't get me wrong. I mean, I'm sure you're doing it for the fun of it, right? Okay. So, now, I mean, there's nothing you can do about that if that's your situation, but I think what it tells you is that perhaps and the world has gotten very, very specialized. And when you get involved in these cases, and I'm there in the pits with it, when you get deposed, I've seen lawyers, my clients, cry, tear up, usually before I get them out of the sight of anybody, but they are extremely apprehensive about it, not so much that they think they did something wrong, but you are not used to, even though no matter what kind of practice you have, the environment of being asked probing questions, and the biggest one being why. Why did you do this? Why didn't you do that? You're not used to that. But in this world, they can ask you that. So in any event, so in those cases, I think that our analysis is again that perhaps a person might take in a family law case and I can do a prenup. I can read up on that and get a form book and do something like that. I use that as an example because I've got one like that where the practitioner clearly told me never had done one before, Mike, but I thought I could do it. And people will debate, for example, in a prenup that, well, is that an estate planning type lawyer to do that because it's dealing with wealth and control or whatever? Is that a family lawyer? And you'll find that there's even debate amongst those practice areas. And I have represented probably every practice area known to mankind in law. I think other than antitrust, although I did have a case that had a spin-off of antitrust. But so in my world, I have to know enough to be dangerous about all kind of practice areas to some degree. So suggestion there is that if you're really in an area, and I understand you want to make money, but if you're in an area that is not really your strength, and yeah, you went to law school and you got a degree, but that's not an affirmative defense that we have in these cases. It isn't going to work. So think about it. Do I want to be in a worst case scenario saying, well, this is the first time I ever did one? Well, did you consult with anybody? Now, I'll go one step further with that. Even in a larger firm, I have to, managing lawyers get deposed, supervising lawyers of others, department chairs, depending on whatever the setup is, and are being asked, well, what did you do about lawyer X? What training did they have? What support did they have? Did he or she go out to Susie Jones next door to him, who is a specialist in that, and did she ever do anything on the file? Because I sure didn't see anything on your time records. So if you're in a firm that you do have people like that, and even if your firm is not too keen on you jumping into an area that you don't have any expertise in, certainly take advantage of those persons that let alone contemporaries. And I've had a number of cases like that where my lawyers, and I wasn't involved at the time it occurred because I see the horror stories long after it's over with, but actually did reach out. And they may even pay a fee, may have given their friend $500 or $1,000 for a consultation on something. It was a nice piece of corroborating and supportive information I had in that case that I could show, well, he or she just didn't do that, they did this. Okay. And so I'll get past the pie chart. All right, what about drilling down? What about the practices of law? And I don't know how well you can see that, but I kind of highlighted some that there have been some ups and downs, but assuming that the majority of you, and the reason that you're here, are dealing with collection and bankruptcy, you will see that 9%, that's going up. Since the last survey, that's going up about 2%. I can't tell you there's a necessary reason for that, other than if you take a look at the time that the study was done, you know, there was a lot of things. We were still, the bubble bursting and all of the after effects of that were going on. So I'm sure you could tell me more about trends in your world of that. But you boys and girls are not, you know, you're up there. You're representing roughly 1 out of 10 claims. So it does happen. And I have represented, you know, bankruptcy and collection lawyers. I only highlight some of the others in that for certain trends, personal injury plaintiff had been 20%. They had been way up there. And now then in this survey, and you can maybe understand why in the real estate area it was, and if you think about what was going on back in 2011 and 2012, you can see why. So then there's more drill downs, and so I only put them up there real quick, but you can see what that survey shows. So if you want to find an area that the percentages are down, that you can do that. And so when I joked about antitrust, you can see it's down to less than 0.5%. So if you want to find that area, that at least in that survey it was down. Okay, I mentioned this already. The trends since the last survey, and that one was in 2008, as you can see, it was close to 2% in your world. Actually went up. I can't tell you what it is today. I think it's plateaued off as best I can tell per the. I went to the spring meeting in New Orleans in April, and that's what was being said there. And then another area was here, but these are all increases of area. And corporate and business organization, I suspect that perhaps some of you are involved in that area, that also went up. Okay, downward, I mentioned the personal injury plaintiff and some of these others. Business transactions went down. One theory was, well, there weren't that many of them back in that period of time. And the people were going out of business. Okay, and before I do the type of work performed, because this is the first survey that actually drilled down beyond the bigger numbers, I get often asked, Mike, what is the average age of the practitioner that you represent on these claims? Now I've had some, there was a number of years ago, I had actually in Naples, Collier County, 2 practitioners that were 50 years plus. So that kind of skewed my stats, but they're gone now. But the average age is of years of practice is 15 to 20. And I think there's some people that fit in this zone there. I think some of you under that. So there is sometimes a perception that it's the younger lawyer, you know, that maybe is the one, or younger, they just haven't had as much experience as others, etc. That's not necessarily true. It does happen, of course, to get into that kind of average, but many times it's in that area and of 15 to 20. Okay, these are types of work. Again, a drill down, and I don't know how well you can see the percentages, but I'll read a couple off that I'm sure you're involved in. The preparation and filing of documents, 28.5%. I can see you do a lot of that. Some of the issues I've had for bankruptcy lawyers in the past have dealt with those kind of issues. Advice, just general advice, 20%. That's pretty standard for a lot of these. That comes up in your kind of cases, what kind of advice goes on. Commencement really deals with statute of limitations, surprisingly, as much as with ticklers and electronic systems and everything else that we seem to have for deadlines. Still get those occasionally. We can still win those cases, but and I'll explain why a little later. And then settlement negotiation and some other areas, investigation, and it goes on down. But those are some of those areas. I don't think we need the pie chart. I think you got that pretty much. And here's some others, a type of administrative errors, follow-up on matters, losing stuff, failing to file something by a deadline, represent a certain percentage. Failing to know or properly apply to law. That's actually gone down over the years. It's showing here with about 13.5%. I think a part of that is due to specialization, that, you know, most people got a good idea what the law is and just, you know, effectuating it in a given situation. So I won't spend too much time on that because I don't want to keep you here all day. Let me give you a brief primer. So anyway, that's the stats. So hopefully you see where you are and where you may not be. Florida law on legal malpractice is not much different than any place else, and there's no rocket science involved in it, and I do know something about rocket science. So, now I'm sure you all had in law school, in torts 101, you had Prosser and et al., and you had the definition of negligence. And in reality, that's all a malpractice case is. It's a negligence-based case. And if you recall what you were taught in law school, it is the failure to do what a reasonably prudent person would or would not do under the same or similar circumstances, right? And that's whether you're driving a car, that's whether or not you're operating a building and you got a premises liability case. It's the same thing in a malpractice case, whether you're a doctor, lawyer, accountant, engineer, architect, or whatever. So there's the definition. And of course, it may consist in either doing something, and this is a jury instruction, came out of the case in Sarasota, so this is hot off the press. But no rocket science here. I mean, there's nothing, it's there. But whatever, doing something that a reasonably careful lawyer would not do, or in failing to do something that a reasonably prudent lawyer would do under like circumstances. That's it. It's not really that complicated. So that's the standard. The basic elements, what you remember about torts, you know, you got to have some connection. Normally in our world it would be an employment, although not all the time. You got to have a breach of the duty. You have to have an established duty and then a breach of that duty, and then to have damages you got to have causation. I mean, again, you had it back in law school. You may not deal with negligence in your world every day, but really in reality that's all these cases are. Who can sue? Well, the general rule of law in Florida in most states is, and what you probably came in here with a perception is, that, well, it's going to be my client who sued me, because that's the person I had a relationship with. They paid me bills, I sent bills to. Hopefully they paid them. In most cases they don't, or don't pay them all, which might lead to a claim. But normally it's that, but there also is a growing trend of non-privity situations that is growing. The plaintiff's bar is very creative. If you're in the estate planning type world or a fiduciary type world, Mr. McHale's familiar with this, I'm sure. You know, he and Luis and his duties as a trustee and those hats, you know, there's duties that you have to other people, and they can easily claim, well, you owed me a duty to do this, and you don't know that. If you're an estate planner, you do the will for dad dies, and the children sue you saying, well, you had a duty to me, you were the family lawyer, you were my dad's lawyer, you should have been looking out for me. Well, other than seeing their name and getting them from the father and putting them in the will, I mean, the lawyer, you know, I don't know them. And so, but there is a line of cases and circumstances in that instance, and there's quite a bit of that here in Southwest Florida because we have a lot of estate planning type practitioners, and there's a lot of claims in that world. So it isn't always your client that you may be hearing from. And of course, it can be someone, again, it can be in another setting that I thought of that you could find yourself in, a business setting with a corporation. You're representing the corporate entity. Well, it's an entity. You deal with people. You have maybe a managing lawyer of an LLC, or a president, or a CEO, or a CFO, or whoever the corporation tells you, okay, Paul, this is who you're supposed to deal with. You got to have somebody. Well, you know, somebody, and if you've got a situation with partners in the business, and even though they may have designated somebody to be the mouthpiece, the spokesperson, and that's who you deal with, those others may, in a worst case scenario, because sometimes those marriages don't go so well, and they may be, well, you know, partner X was doing this, and you know, so Paul, when you did that, I'm only picking on Paul on people I know, so they know better. He doesn't make any mistakes. But I mean, I think, you know, I see some nods in my head, so I know that I hit a chord with some of you in that kind of practice there. So it could be somebody like that, you know, you didn't have a direct attorney-client relationship with, but yet they will be the ones that claim you go back to that you had a relationship to. Statute of limitations. Let me spend a few minutes on this. You may, you know, get into 9511 occasionally, but you may have come out of law school or elsewhere and think of, well, Mike, isn't the professional malpractice, isn't that 2 years? Well, you're right, it is. But it's 2 years from when the claimant or plaintiff knew or should have known they had a claim. And in a non-privity situation, it's 4 years. So now, it's not as easy as many of my clients when I first met them, and many of them I know will say, Mike, you're going to have an easy one here. Look at my bills. The last bill was 4 years ago. And they didn't pay it all, but I decided not to sue them or anything. That was 4 years ago. So you got that 2-year statute of limitations. Just take this and I'll sign an affidavit and that's it. It's not that easy. Just what did I say? It's when they knew or should have known. In addition, there is case law coming out of the Pete Marwick case, and this was a case in jury's periodic world of accounting, that has been applied to the legal side, and that is that until the damages have accrued or finalized, that's when the clock starts. And if you think about that, that's probably long after that last date on the bill. In that specific case, it was tax returns, traditional accounting type claim. I do those for accountants. And the claim was that the accountants missed something. The IRS said they were going to have an audit, gave notice of the audit. They went through the audit process. The audit process takes years, 2, 3, 4. And the argument of Pete Marwick was when the claim came forth, it said to the claimant, well, hey, look, we got the notice from the IRS on this date, and that was more than 2 years ago. So you were on notice that there was a possible issue with the tax return. Not so by the appellate court, and that was, well, that may be the right math, but until there was finality to that IRS audit, that's when the clock starts. So that case was big news in the accounting world when it came out many years ago, and I can tell you it's carried over to the legal side and been adopted on the legal malpractice side. So it's not as easy as the last date on your bill. Let me touch upon another thing. If you sue for fees, which I'm not here to recommend it to you, I'm all for lawyers getting fees. I will tell you that, and I've been doing legal mals since the mid-'80s, but I would say in the mid-'80s to the early '90s, more than 60% of the calls that I would get is, Mike, would you defend the counterclaim? It was not to defend the original suit. It was to defend my client in the counterclaim that they got on their claim for fees. Over the years, insurance carriers and others in this business, maybe somebody like myself, has kind of suggested to lawyers, well, be a little careful there. I mean, we're all for fees. You might want to make sure that case is pretty squeaky clean, but otherwise, the odds are that you're going to get a counterclaim, and the counterclaim is going to say, well, yeah, I didn't pay those fees because you messed up. And even if there isn't anything to it, it doesn't take too much to file an answer that way, does it? No. So, as I tell the defendant side, if you're a defendant in a lawsuit for $400 or so here or on that building over there, you can get into a lawsuit. It's a little harder to get out than $400. So, in any event, and the other thing is sometimes there may be some underlying litigation or other things that are going on. And so that also may be the trigger point for when it takes place. So, and the last thing on if you do sue for fees, you may remember this back in law school. When I did go to law school, I know some people didn't think that. And my degree isn't all in Latin. I recognize that if you come see it. Some of you have seen it. It only has my name. I went to Villanova and anyway, so everything is in Latin. So some people question, Mike, what are all those other words? We see your name, but that's it. But by the way, they won the NCAA basketball this year. But my point being here that if you sue, it was called plea of recoupment, but if you sue for fees, and even if maybe that clock had started, guess what? You've waived, if they sue, have a counterclaim back, you've waived the statute of limitation issue. So it's another reason why you got to be a little careful. And also, the last thing I'll say on that, if you have liability insurance, which I do recommend, and I'm going to talk a little bit about that here near the end, because there's some things that I just see over and over again in representing lawyers that I just feel compelled to tell groups of lawyers on that subject. But this one is, some carriers look at your policy, require you as the insured to let them know if you're going to sue for fees. Why? Because guess what you're going to do when you do get sued and get the counterclaim? You're going to call them and they're going to say, well, why did you file this for $8,000? We now have, a multi-million-dollar lawsuit purportedly on here, and so some of them require you as an insurer to give them notice of that, and I know that's particularly true in the accounting world, but I know that it is in some policies. I don't know of any cases that have tested that from a coverage standpoint, and I don't know of any carrier that has declined to defend, but they have probably done so under a reservation of rights where they've written you a letter and said, okay, we're going to defend this, and we'll call Uncle Mike, but we're letting you know that if there's any judgment on that counterclaim, we may not be taking care of that. So, again, take a look at that policy. Okay. Are you infallible? Are we dead in the water for, no file is perfect. Things happen that we don't have control over. And the good news is that the law does give us a little bit of leeway, and that's particularly true with tactical decisions that are based on fairly debatable points of law. And again, I have represented just about everybody. I know I've seen all aspects of a lot of areas of law, and I'm sure you have them in your practice where I could get all of you and we could debate, and you probably do, some of the areas in your world. And there's some different points of views to some of them, on how to approach something. Well, that's good, because if that's the case, then that's fairly debatable. And there is a doctrine, it's a Florida Supreme Court case, Crosby v. Jones, that I had some involvement in quite a few years ago, 1998, that came out and said that if that is the case, then the lawyers, and it's a complete defense, and we call it judgmental immunity, that if that's established and the lawyer made some decisions in that vein, then he or she should not be held to a standard of anything else. And it's been subsequently adopted. Proto v. Graham in 2001 also came out with said that a mere error in judgment or mistake in a point of law, which has not been settled by the court of last resort, which reasonable doubt may be entertained by well-informed lawyers. You're not going to hold somebody to it. So there is some good news. Litigation immunity. I think of this for some of you because it comes up. Things that are said in pleadings, in court things, and I can tell you, and I do bar grievances, so I see a lot of these for lawyers where and actually, judges can turn in complaints, and I've got quite a few. I've got 3 right now, where a judge has sent a transcript into the Florida bar. So please be careful what you say in there, because, and I'm not knocking the judiciary in any means whatsoever.
About co-counsel or about the judge or both?
No, well, it's about counsel. They're turning it in about counsel and saying, we believe counsel here was out of line in what they argued or a position that they took or whatever. And there are kind of egregious kind of circumstances, granted, but my point to you is that the judges, and they have that task. That's one of their judicial canons, that they also are an enforcer of the bar things. Now, they're not enforcing it, and certainly, yes, they could do things in the case if there's motion for sanctions, but these are things that are going to a level where a judge turns it in. But we do have some immunity for many of these things. Certainly in civil lawsuits we do. These cases typically come from the other side that you beat up on, and that they have said, well, that lawyer, Rich Johnston, just was pounding on me and said this, that, and called me every lying scumbag or anything else. Just called me no good SOB, yada, yada. And there is some immunity with that. And in Holland and Knight, and I was involved in some of the parts of that case. There's a more recent case on that. So if it's during the course of a judicial proceeding, as long as the act has some relation to the proceeding, then it's covered. Now, I've had a case where it was a comment outside in the hallway. Now, well, it was in the courthouse. Does the hallway count? Does it have to be in front of the judge? Does there have to be a court reporter there? We'll find out. But in any event, so there is some. So I thought of you all on that. All right, let me finish the overview of the legal. One of the phenomenons within a legal mal case is the case within a case. It's actually language used in some older cases. And what that means is that when someone says that you did or did not do something that you should have done, when you're in a legal malpractice case, I get to say, well, okay, let's assume my lawyer did or did not do that. Where are we? So what? You never would have been able to prove that case. So, where are we going with this? And so there is that phenomenon. So there's a constant drilling in legal malpractice cases into whatever you were involved in. And a lot of the ones we get involved in had collateral litigation, and we've got pleadings and all kinds of cases. And so I just let you know that's an interesting phenomenon, and so we get to use that. And here's the quickest example of that I can give you, going back to the statute of limitations. Let's take an auto accident. I know you don't do that, but maybe you want to be at Morgan & Morgan someday. You probably know it's 4 years from an accident, 2 years for a wrongful death. We can all do the math. I have defended some of the lawyers, including Morgan & Morgan, on these kind of claims. And so the plaintiff's lawyers in the legal mal will say to me, well, Mike, why are you sending me discovery about my clients, medical expenses, and treating doctor stuff and all that? I mean, your lawyer missed a date, get your checkbook out. Well, I can say, well, okay, I can do the math, but your case in the legal mal is no better than what it would have been had he filed a suit. So I am the defense counsel in that auto case, in essence, in many ways. So, we always have that, so always give us something to do. And as far as the damages, you kind of reverse engineer, as we call it, and that is, what would that plaintiff have recovered had the things that you did or did not do have been done correctly. These are some defenses that we use, and I'm not going to spend a lot of time on that, but we do have some that get into damages. Are they foreseeable? A non-collectability of an award. These are some things that we can play with. All right, spend a few minutes on this, and a file. These are, I'm always asked, the ABA is asked, I'm on that committee, the Florida Bar is asked, I'm on one of their committees, well, how long should I keep a file? Well, we're the right people to probably ask on that because we defend lawyers. Well, I will tell you, and you can correct me if I'm wrong, but I could be, but I don't think so. The Florida Bar only has 2 provisions within the rules about length of keeping a file. And I will tell you, being on these committees, I've often said to these organizations, well, the lawyers are asking you for guidance. Why don't we give them something a little bit more? Well, they always say, well, Mike, you give it to them. We're not going to make a bold statement like that. But the only 2 for the Florida Bar are if you are a plaintiff's personal injury lawyer, that you've got to hold on to the contingency fee agreement that the majority of those lawyers are in for 6 years. What's interesting about that, it's only the contingency fee agreement. It's not the file. Hypothetically, if you read it, it's strictly the contingency fee agreement. And the other one was recently added about 10 years ago, and that's with lawyers more on my side if insurance is involved. There is a statement of insured client rights immediately following the form contingency fee in the rule that says that you've got to maintain a copy of that. And that's a statement that basically says, the defense lawyer, if an insurance company is involved with you, there's a tripartite relationship. But the lawyer represents you, and if you have a coverage issue with the carrier, I don't represent you on that. You and the carrier have got to work that out because that's your contract to get another lawyer. But that's the only documents that the Florida Bar really has specifically said. On litigation files, I generally recommend 6 years. That's here at the top. Probably, applicable to you. These are only recommendations. You can do what you want. And no, I do not have a side business in the storage facilities. I know much is, but it goes further out, and and down here, real estate title opinions, estate planning documents, 30 years. And when I do this in front of the Naples Bar recently with the estate planning boys and girls, and some of them had seen it before, and I'm like, geez, Mike, you must have it. Well, let me give you this scenario. I'm defending a Naples lawyer that did an estate plan, and of course, when would the action maybe kind of accrue? When the guy died, right? The testator died. Guess when the will was written? 1982. How many years ago is that? Pretty close to 30 plus. So, unfortunately, my guy had it, and he had gone to a seminar. So he actually had his file, so that since one of the issues was of going through the intent of the testator, I mean, how many of you know what you had for breakfast yesterday? How many of you know what you did on a will 30 years ago? So there are times when having the file can be very helpful. So in those kind of cases, I suggest those only in that, again, I see the horror stories, and I will tell you that on a file, and I guess I got a couple more minutes, you know, in this jurisdiction, I have had, in the 1990s, I had 4 cases in which the first phone call with my client, and I'm probably much like you, I call them up many times, I know them, and, you know, we're chatting, and I say, well, you know, okay, we got the overview, how about I'll come over to your office, I kind of know something about looking at files, so put me in a conference room, I'll take a look at the file, and then maybe when I'm done, we'll chat, and, you know, we're going to get the other people that were involved in the case, and I hear a little silence on the phone, and it's, you know, well, Mike, I don't have my file. Oh, okay. Well, where is it? Well, the plaintiff asked me, some lawyer sent me a letter and said send him his client's file, and I sent it to him. Well, did you keep a copy? No. So when your first request to produce is to the other side to ask for your file back, it's not starting exactly right on the right foot. I have found a file of a lawyer that left an office. It was no longer practicing there, and he was thinking of, well, I think I put some stuff when I left there, my stuff hanging on the wall, I put some stuff in the trunk of my car, you know, and sure enough, we go out to the trunk of his car, there's golf clubs in there, guess what? There goes the file. So it happens. So I suggest that you want to try to have a file, and here's what's most important in that, and that is that Florida law in most states, that file is yours. It is not the client's file. Don't tell me, oh, come on, Mike, they paid for these services. It does not make it their file. So for those who gave it to their client when they asked, now, you need to make a tactical decision whether to give it to them. I understand that. But for gosh sakes, don't give them the original, unless it's original documents. Keep a copy, or give them a copy. And don't just say to, you know, Susie, the secretary, I'll go copy the Jones file and just go give it to him. You know, you might want to talk with somebody in your office about that, and I know we have procedures in our office where we can tell you that, you know, if these kind of things happen, you know, you need to maybe broadcast that to people, because it's very easy for you to get that phone call and just have your secretary do it, and then when whoever does risk management in your firm or whatever gets it, you know, they're like, well, did anybody call me, or what are we doing? Now, it may not be fatal, but it's not a good way to start. And plus, if you get your file back and you didn't have it, how do you know it's going to be in the same shape that when you sent it? And what about that important memo you tell me about that you swear up and down that you did in there that documented something, and we get it back and it's not there? Now, in the electronic age, maybe we can go find it, which has become a whole other path. So much for, sorry for preaching, but it comes up. So a little less lately, so that's good. Okay, and timesheets. The last one I'll briefly mention here, and that is, you know, I think they need to be kept for a time. I know you have, everybody has different systems and different way of doing it, but I will tell you in a legal mal case, one of the best timelines of what occurred is a timesheet and invoices. Why? Well, you know, you get on the stand and the opposing lawyer will say, well, isn't it your office practice to keep accurate time? Yes. Isn't it your practice to try to be accurate and to do them in a timely fashion shortly after it occurs? Yes. And all those answers that you got to give yes to. And then they'll ask you, well, when my client, Mrs. Jones, called you on such and such a date, I didn't see any time entry for that date. So, you know, the other side can play around with that in some instances, and you know, we got answers for some of those in some circumstances. Also, from the defense standpoint, they can be very helpful. Some people have very little narrative, which is fine. It depends on whatever the client needs are. Some, actually, I've got one right now, and I'm meeting with tomorrow afternoon with my expert and my lawyer, where there's an issue about advice to the client. There isn't any good letter in the file, but what he does have is 2 nice time entries that, I'm not kidding, that are at least that deep. on a time entry for one day, and he's got things that they talk about. Now, that's his style. It's not necessarily my style, but that's his style. Well, thank God for that. At least I got that. And the guy paid that bill. So at least I can say, well, wait a minute, if you had some questions about what occurred on that day, it occurred. So, you know, whatever it is. So the timesheets can go each way, so keep those. All right, how to avoid it, and, you know, use an engagement letter. It's a good idea. A lot of people still don't do it, because one of my questions initially, aside from your file, is, well, just tell me, I'm on your side, remember? You know, what is it that you were to do for your client? And then when I get hesitation on that, I'm thinking, oh, this is not a good story. I'm on his or her side, and they're not quite sure what they were to do. So, you know, it does help to have an engagement letter that might hopefully do that. And it's also equally important in those engagement letters to say what you're not doing. Because there could be, particularly since you're in a specialized area, there may be some aspects of what you do that's not there. So do that. Don't promise specific outcomes. You know, you say, Mike, what are you putting up there? I wish I don't bring them anymore. I could show you some where they'll say, oh, this is a slam dunk. We will win this. Honestly, God, I mean, and what do they become? Artboard on the other side. You know, that when Mike tells them, oh, well, there was nothing to it, that case within the case, you never would have gotten that. Well, your lady said this, it was slam dunk. Well, they still got to prove it was a slam dunk, in my opinion, but it is a little embarrassing for that lawyer to then have to explain this letter. So I realize they like confidence, for you to exude confidence, but I think there are ways to do that without making guarantees. Certainly don't ignore phone calls. Keep a calendar, or some other ones that I mentioned here. I wouldn't criticize other lawyers unless you know all the facts, because that can lead to a lot of different places. Don't reveal you have malpractice insurance. In one of those letters that I'm mentioning, and that actually was a personal injury case in which the plaintiff's lawyer said, this case is worth X amount of dollars. Minimum, or words to that effect. He also had in there, if it wasn't, I've got malpractice insurance. So, I mean, I'm telling you, it's the truth. I mean, I realize I see the horror stories, but it does happen. So don't tell them you have it. I mean, you may have to. There's a Florida statute that says it may have to be disclosed, but I'm just suggesting don't start that way to get confidence. And certainly advise the client of any problems and confirm instructions. And I say that in this way, in that, you know, I get to talk with jurors. We do mock juries, if you're familiar with that process of advance. So I get to talk with people and get their reactions to certain situations. And one of the phenomenons with professionals, and it's true for accountants or anybody else, and that is many of those jurors, and remember, it's 18-year-old with a driver's license. They're not lawyers. I mean, they never have dealt with a lawyer. They have a perception that being educated, that, you know, we should do more in writing and put things down to confirm things. Now, it doesn't say it didn't happen. And you tell your clients that, so I'm preaching to the choir here, but I will tell you, to this choir, many of you, if you get into that situation, we're having this discussion. Well, how come that's not right? Doesn't mean it didn't happen? No, but if there's a swearing contest, the jurors will have the belief that, you know, that lawyer or accountant should have, if this was a technical enough subject, they should have said something a little more. I've only had one lawyer and a standard of care expert testify, and it was a very complicated probate tax matter in Sarasota County. A very well-credentialed expert, the only expert I've ever had, that did say, in that case, he felt it was a breach of the standard of care, not for my tax lawyer to put the various options under some various codes of the tax code section. And, you know, it was tough for me to get around to him, but we had ways. But the same token, so it's not the standard of care. For gosh sakes, the Florida bar says you don't even have to have a fee agreement in writing. It recommends it. But it actually doesn't say it. Contingency fee agreement, yes, but not anything else. So it's very good to confirm things, because if you get in these cases, guess what they're going to say? You're going to say, well, there's no way, Mike, they're not going to remember that conversation. Well, they may remember it, but they're not going to remember it the way you did. And it's going to be, here's what I heard. No, he didn't tell me that. And I got one of these coming up in Sarasota County, and I got a lot of good evidence in my direction, other than my client didn't have a lot of letters in the file, but he's the one that has that long thing. But, you know, this guy's saying none of this took place. And I'm convinced it did, and I think we can convince the
Mike,
jury.
Are
Yes, yes, sir.
emails treacherous or helpful or both?
Emails, obviously, more, if not everybody does that almost now, it seems like. Yes, they're fair game, they're fully discoverable, Rich, and they're good to confirm or not confirm, so it goes both ways. And I'm sure you've heard this, but you need to be a little careful in those things because, you know, when I do things, I think of it as artboard, as I say. Am I going to see this? You know, so think about it before you hit that send button and before you give that knee-jerk reaction that you want to give somebody. Maybe whatever your thing is, count to 100, go take a walk, do it tomorrow. You know, I know everybody wants a 25-word less response within 5 minutes of the time they send you an email. I understand that. But, you know, you still don't have to do it that way. You can, you know, so be reflective of what you say because it can be interpreted differently.
I have the circumstance that when I've got a fairly complicated thing, I want to talk to the client and tell them, because it's to do an email, I'd be there, you know, writing a tone. But then memorialize afterwards?
I would say that, or if nothing else, you know, maybe an email to them. Listen, we talked yesterday and I went over 5 points with you. You know, you may not have to do that, but at least it documents something, Rich, that we can go back. Well, he mentioned 5 points. You know, well, what would, you know, maybe they're not going to say 5, but at the same time. So even something just short like that is somewhat confirmatory of the event having occurred. Because, I mean, it's gotten to the point, I realize that, you know, you think of, Jesus, Mike, I mean, maybe you feel it already. It seems like, you know, you have to practice defensively.
Yeah.
You do? I don't think there's any client that I've ever had that would answer that question any differently after having gone through a malpractice case, no matter at what level. That, you know, yeah, you know, there are things that, you know, I could do or not do. I mean, it may not prevent the claim from being there, but what I'm talking about, at least you've got some further ammunition to defend it. Yes.
I'm not an attorney, but sitting here, could you talk your clients into, and could you keep audio records? Like, we're going to put this on a tape recorder.
You could. If you have their permission.
Make sure you put
Certainly,
permission on the
you
tape.
can do that. But that's, you know, for lawyers, I would say, you know, this gang can respond there. I mean, that's a little awkward. You don't want to have that kind of, you know, relationship like there's anger and all that. And again, usually you like to think of your clients on your side. You're trying to help them, whatever side of the fence you are. But, you know, they're not, in my world, they're your enemy. I mean, I'll give deference and I'll be polite and professional, but on the other hand, they're the enemy. You know, so, you know, and I realize that, you know, it takes a while sometimes a lawyer to really understand, oh my gosh, my client said that. So it could be done, but it's a little awkward. Let me finish up. I know Luis wants to get you out of here. Here's one it's coming up more and more, and I just want to highlight it since that's what I was supposed to do, I think. 4-1.2, it's been there for many years, and it talks about limitation of objective and scope of representation. And I always wondered about it, and I think maybe some people that are using it now have gone to some of these seminars of mine, but what this basically says that if you're going to limit your scope of something, you need to put it in writing. It's an ethical rule. And I know scopes and certain things can change in a case, and one can debate, and I just did in the trial in Sarasota, over whether was it objective, was it a scope, was it a means to an end, and it related to the hiring of an expert, which I'll come to in a minute. But so my point being here, and this really historically, if you look at it, came through the family law section, where they can deal with estate planning issues, accounting issues, tax issues, and they're a family lawyer. And they may be able to perceive that, but they've got to hire those kind of people, or a real estate appraiser, or a business valuation expert. And so, you know, they can't be expected to do that. Although I will tell you, and I'll jump into that example, in that I've had a case for a family lawyer in Naples, so if I mentioned her name, many of you would recognize it. It was a barn burner for a number of years. And we had one of the first Daubert challenges in Southwest Florida. I think it was the first one dealing with an accountant was on the other side there. And it's gotten known in the accounting world because we were successful in limiting this accountant and doing certain things. But one of the allegations in that case against my lawyer was that when the business valuation expert that she retained did his evaluation, and he also was sued, that he didn't do it right. And she should have picked up on that. Now, I did get Judge Starnes, who was filling in on that case, to dismiss that count because, and as he, as I somewhat said to him, which I can sometimes do in hearings, like, Judge, if it's going to be now that the lawyer, that I can understand hiring or not hiring an expert, dealt with those. But once it's hired, short of, not giving the person something or whatever, but if you're drilling down into what that person's specialty is, that's why you hired him. I mean, I'll never retire. How many of you have experts in the case and that you're expected to know the ins and outs of the techniques or whatever, and whether or not this guy should have done more, should he have done this, a review of financial statements and all of that. I mean, it was drilling into the weeds, but it was allegations. We got him struck. They kept trying to bring him in, and there was an overtone to the case. So it's a nasty world out there. All right, I got to finish up.
Mike, one thing
Yes, sir.
on your, how to avoid getting sued. In this bankruptcy context, the attorneys have to know who their client is. It's a small corporation, and I'm going to say, I'm not an attorney, 70% of the time, the people don't make a distinction between the owner of the corporation and the corporation. Believe me, I'm not.
Good point.
Yeah.
Good point. And I think I touched upon that as a gentleman, so thank you, Jerry, for adding that. And I know that's true. And it happened. I can see it happen. You're dealing with a person, and if a divorce comes place in those businesses, you might be the last to know. All right, what are some danger signals? Obviously, if you have a dispute over fees, might be something between your shoulder blades. Maybe Starnes, so be a little careful of those. Obviously, a motion to disqualify, it doesn't happen that often. Obviously, if that occurs, there's something maybe that should be of concern. Substitution of counsel, your client says, well, I want to use somebody else right now. Maybe you did or did not have any problems leading up to that. Not that you need to do anything, but I'm just telling you just to be careful of these. Subpoena for firm documents, my little horror story on that, kind of like the file type of thing. Also, if you get served with a subpoena for documents, what did I say? It's your file. So, there is a thing called attorney-client privilege. And I don't care if it's the IRS, it's the FBI, whatever, we can work through that. I did have a case for a local accountant here in town. If I mentioned his name, you'd recognize it. He was very embarrassed. When he called me, it wasn't Jerry, he already gave his file to the U.S. Attorney's Office in a criminal case of his client. You talking about a hypothetical, or are you talking about this has just happened? No, Mike, it's just happened. Well, fortunately, Mr. Malloy was still in the federal U.S. Attorney's Office there, and Doug's an old friend, and I called up, Doug, Mike, what are you calling for? You didn't like, oh, we don't do that kind of stuff. Well, I kind of, so I got it back. But, and so you need to be a little careful, let alone copying them, but also on what you do with them. And frankly, the accountant-client privilege in many ways, and Jerry probably knows this, heard me say it before, in many ways I think it's actually a little stronger than a lawyer. So be careful about that. You may want to, and you may get some help from your carriers. Some of the carriers now have gotten, particularly in the CPA world, that if you get something like us, even though it's not a claim, what is a claim? 100-year-old definition, a demand for money or services. Well, Mike, nobody's demanded anything. I understand that. But some of the carriers, because they know these can be dangerous signals, they might authorize retention of a counsel to assist you in that process that maybe you could, bounce it off of and make sure all the I's are being dotted and T's are being crossed. Obviously, if you're subpoenaed for a deposition, with or without records, could be an issue. You could be just a fact witness, but I've had many a case where when I'm talking to that lawyer about things that have happened, I'll send you my deposition too, Mike. Oh, okay. Already been proposed? Well, yeah, there was this case, I told you this other case, and, okay.
Mike, one other area too on the, we do a lot of Ponzi scheme work. Aiding and abetting. I mean, I don't know how many attorneys I've seen that inadvertently stepped over the line.
Yes.
In what way, Jerry?
Well, I have one that indicated in 1031 cases that it was okay to borrow from your escrow from the 1031 funds. And he put it in writing, and they used that.
To connect up the dots for aiding and abetting.
It cost them their whole firm.
Yeah.
They paid policy limits on day one.
Yeah. I've seen a couple of those too. Thank you, Jim. All right, lastly, we're getting close, bar grievance. Obviously, if some of that's going on, then that could be also a danger. Sometimes bar grievances come with malpractice claims, sometimes not. It probably depends on a lot of circumstances. There are some plaintiff side of cases that will do it to try to create a distraction when you're dealing with both kind of issues. Let me talk about liability insurance to wrap up. Am I okay, Louise? I'm okay, got another couple minutes?
And some people need to get good upstairs to court pretty soon. But.
Okay, all right. Well, these are a couple. I don't sell insurance. I deal with insurance companies. I know a lot about insurance policies just by osmosis over the years, so I know enough to be dangerous. And actually, law firms call me and ask me my advice on, about either carriers, limits, other issues, and so I guess somebody must think I know something about it. But so, and I know insurance policies are not exactly easy to read. I don't care what all the TV ads for everybody says. They got a little better, but they still got issues. But there's some fundamental things about them. And here's what's peculiar about professional liability policies. They are claims-based policies. Well, what's that mean? Well, your traditional policy, auto, homeowners, and a lot of others are what I'll call occurrence-based. What's an occurrence? The auto accident, the trip and fall, a very defined date. That defines the policy. That defines what carrier defends it. So if Paul's in an auto accident today, he gets sued 3 years from now. He had USAA today. He's got Hartford or Progressive or somebody 3 years from now. He doesn't go to Progressive. He goes back to the carrier of today. In legal mal, they are a claims-based policy when the claim is made. What did I tell you a claim was? Demand for money or services. Now, carriers sometimes will look at a situation, and that's why you need to stay in touch with them, because if you don't tell them about a claim, that carrier that you had at that time may be off the hook, and then if you decided not to get insurance, and you have it when the lawsuit gets filed, you call that carrier, they're going to say, well, maybe not, so it depends. So that's number one. Number two is that, limits, it's, in my opinion, is whatever you can afford. You can get charged from them quotes. They want to sell you insurance. Various limits. I do not recommend $100,000 policies because in this day and age, the typical defense costs, and I'm not the most expensive guy in town, but I don't think this will shock you. But if we go through from beginning to end, experts, court reporters, and everything, it's a $50,000 to $100,000 case at a minimum. So, it goes there. And compounding that is, and here's the one I really want to drill home, there is a feature, in order to get a lower premium, a lot of these professional policies are what they call declining or wasting limits. What are you talking about? And they may use that. It's usually in the insurance coverage section, and the function is this. Where do the claim expenses, the defense costs, go? And on those kind of policies, with a lower premium, the defense costs come off the limits as the case goes along. So, if you have a $100,000 policy, and you can understand why I'm using this example, because I think I've got 3 of these right now, and I've had this discussion with 2 lawyers within the last 2 weeks, and they had no clue until I told them. And I'm on their side, but I thought they needed to know. So that means that we can, fight till the cows come home. And at some point in time, that $100,000 may be gone. And guess what they get? They get a letter from the insurance company that says, we satisfied our obligations. You're more than welcome to continue on with Mike. Please make your own arrangement with him. Now, it doesn't happen that often, but I'm seeing a lot of those policies. So and I understand premiums cost money and all that, but my point is, at least make sure you're making an informed decision on that. Take a look at it. Ask your agent or broker or whatever, is it declining or not? Because if you have those kind of limits, now it also applies to larger limits. And if you got larger limits, that's a different thing. But if you have 100 or 250, just remember what I said. Because we could go to trial and win on those kind of cases, but you may have nothing left. And, fortunately, I don't know too many horror stories about it, other than I know that some of those lawyers, when they found that out, and I expect the 2 I told in the last 2 weeks, when they went home that night, they may not have slept as well. Thinking about that kind of scenario. So,
in the bigger cases, Mike, the wasting, actually actually, many times works in favor of the client, because if there's a $20-30 million policy out there, then we're talking fees in the $5-6 million range.
Sure.
I'm more than willing to sit down a little bit and see what we can.
Exactly, and we use them that way, Jerry, to negotiate, because we end up having, we tell the other side, certainly they're,
Yep.
and most of the time, frankly, on the other side, I gotta tell them that too.
Yep,
They don't
exactly.
see it at first, and I'm saying, well, look, maybe we better talk settlement now, because, look, there isn't gonna be anything left.
Right.
You know, we can, you know, I'll beat you academically, and I try cases, I mean, I just, 3 weeks ago, but, you know, I'm telling you, practicality-wise, I mean, there may be nothing left. And certainly I would have an obligation to that lawyer to tell him or her that, look, you know, we better forget about the merits. I know you don't want the lying scumbag to get $1, but, you know, I don't know. You know, you want that letter from the insurance company, we're not going to be done. You know, I can't guarantee anything. If you get hit for more than $15,000, you might be some of your money. Be it a firm or person individual.
Don't think of me as a lying company, okay?
That's right. No, I'm not. I didn't. Sorry about that. That's a good point. All right, last thing is, if you're departing a law firm, please follow the rule. That's a relatively new one. I seem to get a lot of cases on that. I'm involved in a number of law firm divorces, I call them, between a former lawyer and his last firm, and there's a script a little bit in 4-5.8 in the rules. So thank you very much, Louise.
All right, thank you very much.
Thank you.